pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let us pray. Good and gracious God, we thank you for this beautiful day. We thank you for the creation that you have given to us to care for. We ask that you fill our hearts and our minds and our spirits with your loving kindness towards one another today. We ask that you fill us with wisdom and your will to do what is right in this place. Bless our county commissioners, all people who serve, and all the people who are gathered today. We ask that you continue to help us to be present in this world. In Jesus' name we pray. Amen.
Thank you. Thanks, Kelly. Next up is a public comment on anything that's on the agenda today. If you have anything, step to the podium, state your name, your address. For anybody that's new, if there is anybody, that public comment is limited to 3 minutes per person, one time. And it is public comment, it is not confrontation or a question and answer time. So if anybody has anything, feel free to step to the podium.
My name is Bunny Sutton. My address is 2191 East State 75 North Crawfordsville. My son will be 19 next month. He's intelligent, sweet, and funny, but he was born with a lot of mental health issues. His father and I have spent the better part of the last 17 of his almost 19 years in and out of psychiatrists and therapists' offices so that we can give him the best quality of life. He has a listed diagnosis: autism, major depressive disorder, sensory processing disorder, and in the last few years they've diagnosed him with agoraphobia, which is a fear of leaving the home. His sensory disorder makes tasks we all take for granted, like brushing your teeth, taking a shower, wearing shoes, sometimes painful and always a traumatic experience. With years and years of therapy, he's been making a lot of progress, and we've been able to keep him at home with us and not put him in an institution or a group home. A couple of weeks ago, all of our efforts with him took a big slide backwards. A wind testing tower went up directly in the line of sight from our front door and only a couple of 100 yards behind our barn. We had to take him outside and show him so that he wasn't surprised by this giant new neighbor. We live on a gravel road with no neighbors. We had to explain to him what this was, and his anxiety has been worse. My son, while having a lot of mental health concerns, is a very intelligent child. He began doing his own research on the wind turbines and discussing things online with his friends from around the world. His anxiety the last couple of weeks has prevented him from sleeping much, taking a shower daily, and interrupted the progress he's been making. I approached his therapist last week at his appointment with my concerns about the turbines affecting my son's progress in the future. I was not surprised when he said that the test tower alone is already having a negative effect on my son's progress. He wants our family to no longer discuss the wind farm issue in the presence of our son. We need to redirect our conversation if he brings it up. And we need to start thinking in a positive way about this situation, because it's something that might be in our lives very soon. Our son has physically harmed himself on numerous occasions due to his problems beginning at the age of 4. He's been admitted to a psychiatric hospital 3 times because he's attempted to take his own life. We've worked really hard to give our son the best life possible and to keep him at home with us. If this project moves forward, it's going to keep setting his progress back and could quite possibly put him in such a state that I'm not able to keep him at home with me. Not us and not anybody else deserves to have our lives ruined by something like this. Thank you.
Thank you. Anybody else?
My name is Bill Mallon. I'm with the U.S. Highway 231, Montgomery County. We are working to protect the health and safety of our citizens in Montgomery County. I want to talk about the terms conversion and conservation. The title of the ordinance 2018-4 is, quote, Ordinance 2018-4, Ordinance amending noise regulation of wind energy conservation systems. You should have used the term conversion here. You also used the word conservation 4 times on the first page of the ordinance, when you should have used the word conversion. Chapter 155 is about wind energy conversions systems. That is what the acronym WECS stands for. These errors may not have been intentional, but nevertheless, they are errors. I realize that once an ordinance is named, you probably cannot change that name. What you would have to do is abandon that ordinance and start a new ordinance with the correct name. That might be Ordinance 2018-21. I know that it may seem inconvenient, but it is important to have things correct. The use of that incorrect term throughout page 1 of this ordinance makes all of these statements on page 1 incorrect. These errors in this document could have a substantial impact on things in the future. I cannot look into the future and tell you what will likely happen, such as in a future court case. What I can say is that in my lifetime I've seen situations where when a little error was not corrected early on, the consequences turned out to be really bad. Sometimes it takes 100 times as much effort or 1,000 times as much effort to correct an error down the road when it could have been corrected up front. I think it is a big mistake to go ahead knowing that these errors exist in this ordinance. Thank you.
Thank you. Anybody else?
My name is Justin Smith. My address is 53 North, 400 East, Crawfordsville. Commissioners, Mr. Bain, Mr. Fuller, Mr. Fry, I have come to you today as a member of the community, as a father, and as a veteran. I know you have some tough decisions to make on industrial wind turbines. I too know what it is like to make tough decisions. I made some of those decisions at the age of 18. I wrote my own will and last testament at the age of 19. I did so by doing these things because I made the decision to join the United States Army, to defend the Constitution of the United States and our way of life. I've made some tough decisions to leave my family so that I could protect yours. I served almost 8 years of active duty service. I did 2 combat tours, one in Kosovo, another in Iraq, one at the age of 19, another at the age of 21. I was legally a combat veteran before I could drink a beer in this county. I fought to defend our rights and our freedoms, but now I feel those rights are being held in jeopardy. My right to own property without being infringed upon. I should not be limited to restrictions on my property where I pay the mortgage and taxes. These setbacks are not near great enough, and in no way should I or anyone be allowed to have a structure that infringes on my neighbor's property rights. And those rights should not be determined by my property size. I've given and paid and worked for my property just as a larger landowner has. I've been to war for my property. Have you? We veterans fought and sacrificed our lives and health to defend your rights. Now we ask you to fight for us. The health of our veterans is far more important than the industrial turbines are. Many veterans don't have the means or ability to relocate for many reasons. We have fought for our rights to our own property without being infringed upon. Gentlemen, we have fought our fight to give you the opportunity to sit where you are. We fought to give our children the freedoms we enjoy. Those freedoms are not given, they are passed through a bloodline that has been bled and died in every generation so that we may live free. This decision should be long and deliberate. Our ordinance should be for the best interest of our community. It should not allow anyone's property rights to infringe upon their neighbors. Thank you.
Thank you. Anybody else?
We ride 16210 North State Road 25, Waytown. I have a little article here that was taken out of the Lafayette paper either June the 28th, 29th, or 30th of this year on animal confinement setbacks. In Carroll County, 800 feet from a residence, 1,500 feet from a residential zoning district line, church, school, park, or public building, 3,900 feet from an incorporated town. White County, 1,320 feet from a residence, business, or other non-agricultural district. Tippecanoe County, our neighbor, is 1,000 feet from a residence, school, or any other public building. A 5,000 head hog unit next to your house is going to be worse than a windmill. Thank you.
Thank you. Anybody else?
Seth Howe, 2210 North, 625 East Arlington. I'm not sure what you're going to discuss this morning. Hopefully everything I'm about to say is a moot point because you've come to the same conclusion. We've had 3 stabs at this ordinance regarding protections based on noise and setbacks. Our initial ordinance had protections of 60 decibels at the structures, setbacks of 1,300 feet from the residents and non-participants, and 1.1 times tower heights from property lines, which are much too close, but no one here may have known that 10 years ago. After months of testimony and evidence presented regarding the mountain of problems with industrial wind turbines, it appeared that you were in agreement that additional protections were necessary. In February, you introduced a reading of a revised ordinance, which had protections of 48 decibels from property lines of non-participants. You also included setbacks of 1,500 feet from non-participating property lines. Although these setbacks were inconsistent with what other counties in our state are implementing, that is, that they're much more lenient, the pro-wind folks became very concerned, creating websites, petitions, etc. to block this ordinance. A few more 100 feet from property lines would not allow them to build. They must have gotten someone's ear because that ordinance fell silent for 3 months. We now have an ordinance in front of us with an increased decibel level by 2 decibels to 50 decibels. We also have another designation for folks. We have combined participating landowners and people with over 5 acres. This group will receive equal protection to their residents. Both will get 50 decibels and 1,000 feet. If you're lucky enough to own less than 5 acres, you'll receive protections of 50 decibels and 1,500 feet to your property lines. Somehow we've come up 2 decibels and segregated folks by how much land they own, by an arbitrary amount of 5 acres at that. I don't know if it's intentional, but it sure seems like someone is making minor adjustments and creating loopholes to appease the wind company. We now have a segregated group of people who 10 years ago had more safeguards. 10 years ago, they had 1,300 feet protection from the residents and a 1.1 times tower height to their property line. Now they only have 1,000 feet to their residents. I know you fear lawsuits from the wind company, but I believe you discriminate against those that have more than 5 acres, which is many people out in the country. I believe you need to consider that you could be sued by those you are supposed to protect. As I say every time, we're much too populated for industrial wind turbines. 1,500 feet at that is not nearly enough protection. Let's get in line with what other counties are implementing, 2640, from property line or more, depending on how big these things get. Thank you.
Thank you. Anybody else?
Corey Galpo, Crawfordsville. I have more petitions against the proposed wind farm projects in our county. We have signatures from folks in Wingate, New Richmond, Elmdale, Waynetown, Alamo, Waveland, New Market, Ladoga, New Ross, Darlington, Linden, Crawfordsville, and also from Montgomery County landowners that live out of the county or state.
Thank you. Anybody else?
Good morning, I'm Brock Irvin, 630 North Forest Road. I wasn't planning on speaking today, but I do want to at least be one person to speak up in favor of the wind farms. If somebody comes into your house and turns up your thermostat by 2 degrees, are you going to notice it? If they turn it down by 2 degrees in the winter, are you going to notice it? Since the early 1800s, our global temperature has already risen by 2 degrees. That's in the last 100 years. In the next 30 years, the consensus is that we are going to see the same amount of climate change that we've already seen in the past 100 years. So that's another 2 degrees. That's actually going to be over 2 degrees. By 2050, we're supposed to see temperatures having an increase of 4.5 degrees Fahrenheit. We can't ignore this problem. This is a global issue, and we've got to deal with it. It's not one country's issue over another. It's not one state's. It's not one community's. It's up to everybody to step up, and this is our chance to do that. I also want to comment on the complete avoidance of any issues financial. We're looking at millions of dollars that can benefit our schools, our roads, our neighbors and farmers. People act like that's a selfish reason. That's not selfish, not when our schools are losing money right now. We are very concerned about the health effects, or the health and safety and well-being of all of our neighbors. And I really just hope that standing up in favor of this does not imply otherwise to any of you in this room. The research on wind farms is extensive, and I understand that there are certain stories out there that, not stories, situations where it has been a problem. But overwhelmingly, the evidence is against that it's any substantial issue. Thank you very much.
Thank you. Anybody else? Okay, hearing none, we'll move on. Next on the agenda is approval of minutes from the June 25th, 2018 meeting. I would entertain a motion for approval.
So moved.
Second. We have a motion and a second. Any discussion or changes to the minutes before the vote? All in favor of approval signify by saying aye. Aye. All opposed? Motion passes 3-0. Next up is approval of the claims from accounts payable and payroll claims. Jennifer?
Yes, hi. I have the accounts payable claims docket in the amount of $609,604.21. And then we have the July 6th payroll docket in the amount of $338,639.47.
Move to approve. Second.
We have a motion and a second to approve the claims as presented. Any discussion or questions? All in favor signify by saying aye.
Aye.
All opposed? Anything else, Jen, from the auditor?
No, that's okay. Thank you.
Looks like we're down to reports for department heads, elected officials, and Sherri.
Morning. I'm requesting approval for out-of-state travel in September to the MIC Conference for International Association of Assessors. I do have sufficient funds in my line item for that.
This time I'd entertain a motion for approval.
Move to approve.
We have a motion and a second. Any discussion or questions for Sherri?
Yeah, this is ridiculous. I've said it every time they come to us, the council needs to change that. They've got a budget, line item in their budget that's been approved for travel. Unless they overrun that budget and need additional, that's their budget. That's my recommendation.
Anything else? All in favor of the out-of-state travel in September, signify by saying aye. Aye. All opposed? Motion passes 3-0.
Thank you, Chairman.
Any other elected officials or department heads have anything? Okay, moving on to old business. Old business is ordinance 2018-4, and Dan?
2018-4 would amend your noise regulations for the wind energy conversion systems. And the ordinance would do the following things to your current ordinance in chapter 155. It would lower the amount of noise allowed from 60 to 50 decibels. And then it would indicate that the measurement of those at that sound level would be from the primary structure for participating and non-participating landowners with less than 5 acres, and more than 5 acres. Non-participating with less than 5 would be measured at their property line. It also creates new noise buffer areas, and those we tweaked a little yesterday, Mr. Bain and I, so those new buffers, the non-participating would remain the same at 1,000 feet, except we would also make it the greater of 1,000 feet or 110% of the height of the tower. There's been some speculation that tower heights may increase, and so that has been changed to account for that possibility. The second noise buffer is for properties, non-participating property owners with more than 5 acres. And again, we've added the 110% of height, and the distance has been changed from 1,000 feet to 1,400 feet from the primary structure. The non-participating landowners with 5 acres or less, the distance has not changed, that remains 1,500 feet from the property line. We've added the 110% of tower height again to deal with that possibility. The ordinance is the same in that it retains the right of property owners to waive any of the requirements of the ordinance. And also the grandfathering provisions are the same. We've allowed for the extension of the permits. The initial permit is 2 years, and we have allowed for extension of 1 year. That's not changed since your last meeting, but that's a change from the existing ordinance. And then we've added section K, which is an enforcement provision. Made no changes since your last time you've seen it. But those are the changes that would go into effect for this ordinance.
Okay, so you guys have heard the changes that have been made to the 2009 ordinance. At this time, I will make a motion to approve ordinance 2018-4 for discussion purposes.
Second.
Gentlemen, you got any conversation or discussion?
Right where I've been all along here, we're going through a process now with the, with the comprehensive plan that's identifying the will of the people. I just think this is premature to take this step until that's completed. We're talking the next, 4 or 5 months to finish this up, and I think we're so close now but that's my opinion. I know we've got a lot of people on both sides of this wanting us to move. Let's just get it done. I understand that, but we have a process, and I just think we need to follow it. So that's my opinion. I'm not saying this is the wrong approach here and what the wording says of this ordinance either. Honestly, if the will of the people is to not have wind farms, then this ordinance doesn't matter. We don't even need an ordinance. So, and if there are areas of this community that the people want are okay with wind energy, then this is probably not the right ordinance for that either. So, anyway, that's my view on it. I don't just want to get this over with, when we're going through a different process, it's really going to solidify what the will of the people are.
I guess I'd have a question then. What if somebody comes in today and files for a permit? What happens?
We are absolutely exposed. What the wind energy folks have told us is that the uncertainty is the reason that they're not. The agreements that we have are negotiating right now with the infrastructure, all those things, this agreement. If keeping I've asked the wind energy folks to give us a year to go through this comprehensive plan process and let us decide as a community what we want. And I haven't got a commitment from them on that, so I definitely don't want to grease the skids to get permits. If this is one thing that's uncertain today, and now it's answered. I don't know. I guess I don't want to put us in a bad position either. If they get a permit that this doesn't pertain to, but I can't imagine that that's the case. Is it, Dan? I mean, the wind ordinance. How would that pertain if they were filed for building permits today? How would this agreement change, affect that, or if they did it today before we did this tomorrow?
If you don't take action on the ordinance today, they can apply under the current ordinance for a permit.
That's where I'm at. I mean, this is only an improvement to what we had in 2009. But this could go down the road right now. There's no uncertainty to them. They can put them in today at a 60 decimal level. I mean, file for their permit at a 60 decimal level today. And nothing being interchanged. So even though there's some things that people think are not to what they want, it's an improvement to where we was in 2009.
I would agree
I think
with that.
Seth kind of talked about some of that. I mean, we went from 60 to 50. Nothing has got on the better side. And that's kind of like Phil said about a month ago at our meeting when we had this discussion, is this amendment is an amendment to what's already out there. And it's taking it in the direction to the 50 decimal instead of higher. So, I mean, I don't see how it's not a step in the right direction. I mean, there's no guarantees that they couldn't file today and go down the road if we don't amend it.
Yeah.
So that's kind of where I see it at. And some of the changes that they're talking about wanting to be made will not be able to be made until we do have a full set of comprehensive plan and zoning in place. And, so like I said, you wait that out for a year and who knows what you might have. So that's kind of where I'm at on it. I think we've done the due diligence, I guess, and gave us, the time and looked into and listened, and, I feel that from what our attorney tells us, what the law says, that we've done what we can do. And, I mean, that's just where I'm at.
I would agree with that. This ordinance is not going to regulate out wind energy.
Right.
It's not. And we have to keep it defendable. I mean, we do. We can't make this an ordinance to regulate out.
I agree.
Yeah. So, well, I appreciate you sharing it. I mean, it's so hard. The commissioners can't talk. And we send stuff back and forth to Dan, and until we get in a public meeting, do we truly know what everybody's views are. But I would agree it's definitely a step in the right direction.
So, and not saying that we want to do this, but, I mean, we're amending an ordinance today. Not saying if we don't see something down the road that needs to be amended that we can. I mean, if it's not, you know what I'm saying?
Yeah.
This is not saying this is locked in, dead, set, this is the way it's going to be. But I think we're improving what was done in 2009, in my opinion.
So, Dan, what happens if in fact planning and zoning does go through? I guess either way, I mean, if you left it at 60 for John's request, or if you made these modifications, then in both cases, what happens when planning and zoning, or if planning and zoning would happen to be instituted?
Well, if you had zoning, you would have a conversation about where wind, energy, or any other land use could be located in your county. And although you have to identify some area of the county where all uses are available, whether it be industrial or business or whatever, then the conversation by the community would be what's appropriate to be located where, what conflicting land uses should not be next to each other. Where they're located is, that type of land regulation is zoning. So that's what would happen. You would have that conversation and create a land use map with zoning districts and would show what is allowed where. And you've heard strong sentiments by people that say, I don't want it here, or you've heard people say it's fine with me, and that is part of the zoning process, and that's what communities do. They decide where certain uses will be. As we've discussed, this ordinance is just about the regulation of noise. That's what this is about. But the issue that everybody really talks about is different. The issue is land use, and again, you're one of 3 counties that don't have that tool available to you yet. But if you have it, you would create maps and you would define what uses were permitted by right in each district, and what uses were permitted with special review, and we call those special exceptions. And that would mean that certain types of uses, if they're allowed, require more scrutiny, and wind turbines might be one of those. Usually cell towers and certain industrial uses can only get approval, even in areas where they're designated, they're allowed with an extra layer of review called a special exception, because they often come with certain conditions, and those conditions would be things like, buffering and visual appearance and that sort of thing. But those are the kinds of issues and the kinds of conversations you would have if you had zoning, and you, again, as Phil and Jim both mentioned just a minute ago, zoning ordinance is an ordinance. Although it's usually a document which is produced after quite a bit of conversation, it too can be changed at any time. So you may decide, you could decide in your original ordinance that the people in Franklin Township don't sound like they want wind turbines. We'll just say they're not allowed over there, but they're allowed elsewhere. And then 5 years from now, that may change. People change their minds. So it also changes over time. And my clients who have zoning change theirs. They change their maps all the time.